My Lords, my first point in reply was to try and wrap my head around fundamental facts and what is meant by this. In short, we say this thesis was not advanced in my learned friend's skeleton. It's put forward for the first time in their oral submissions and has no discernible, as far as I can see, basis in law. No authorities were relied upon with respect to it. With respect, it is smoke and mirrors, confusing or seeking to confuse what is a well-established principle of there being accepted facts, disputed facts, and the burden of proof. If there were to be some prior notion of fundamental fact, it's entirely unclear how this operates. Is it a two-stage?
I think the phrase is foundation.
Foundation, sorry. Foundation fact, sorry.
I think the point is sufficiently clear. It may not be a good point, that's a different matter. But I think it's essential that before you get on to any reverse burden, that there's always something that the state has to prove just to get things off the ground. To say that somebody was in possession of something, or they are liable to be registered for something. Often, as you say, that may simply be the matter of admission or an agreed fact. But if it is disputed, Mr. Webster submits, the onus is on the state. Now, you get the show rolling, and then there may be a reverse burden on reasonable excuse or something like that.
But my conceptual concern or response to that is, well, is a foundation fact not just the issue in dispute? Are we just not talking about the same thing in terms of
not necessarily, because it depends what you mean by issue in dispute. If the issue in dispute is in a penalty case, dishonesty, for example, or intention, something, so the sort of thing where you accept, you do. If that's what's in dispute, then it's clear, it's common ground. The burden is on the state. But what he's saying is that just to get things going at all, there will always be something. Otherwise, you can just say to the citizen, we impose a penalty on you.
Indeed, but then my submission would be then obviously there's then a burden of proof. Say we're just dealing with an ordinary tax liability, just leaving a penalty aside for one moment. We're dealing with an ordinary tax assessment. There's a burden of proof. There is a plethora of facts. Some will be accepted, some will be disputed. And then if there is, if the tribunal is unable to make its mind up on the key issue in dispute, that burden then comes into play. But it's just dealing with that melee of facts. There is no earlier separation or two-stage test to establish some foundation facts in law before that point. So my learned friend's example, when he was using the example about Euro wine, saying, well, they're in possession of the alcohol and that's a foundation fact. Well, that was an accepted fact. Had they been disputing possession, that would have then been an issue in dispute.
Yeah, but who would have had the burden on that?
Well, then we go back to our submissions, because we say paragraph 7 of Euro Wines is obiter and per incurium, and so we say for those issues in dispute, it's on the taxpayer. My learned friend says it's on HMRC, but that is essentially the issue we have been discussing for the last 3 days, is who has the burden on the issue of liability.
Yes.
So I still, respectfully, have significant conceptual issues, and I don't think there's any case law to support this notion of an earlier foundation fact. And what happens if there is a dispute as to it? There has to be a prior hearing. It just has no basis in law, we respectfully say.
Well, that submission I understand.
So we say it should be given short shrift because it has no basis in law, and in reality is confusion to the issues that you have to face here as to what is well-established principles as to the burden and liability. The second point is just to briefly go to the Janovic and Swedish case, because there was some confusion with respect to paragraph 98 and the second, the middle sentence there. So if I could just take the court to volume 2, tab 30, page 550. In fact, I think it was page 549, because it's paragraph 98 was the one that was having the discussion. And the line in question was whether the second sentence in paragraph 98, the cases are to be examined on the basis of the evidence presented, and it is for the tax authority to show that there are grounds under the relevant laws for imposing the tax surcharges. And the debate was whether that was just referring to the facts of this case or a point of general application. Well, we say it was very much referring to the specific facts of this case, but you can see that was part of the submissions made by the Swedish government at paragraph 73. So if you go up to page 543, and paragraph 73, and it's 7 lines down, where there's the page, red page number 500, halfway along, there's then a sentence saying throughout. So this was the government submissions. Throughout the tax assessment proceedings, it was for the tax authority to prove that incorrect information had been furnished, and that consequently there were grounds for imposing tax surcharges. So in other words, that lends support, we say, to the proposition that middle sentence was simply a recount of the facts of this particular case rather than a general principle. The third point is to go to King and Walden and the passage that was causing some confusion. I think it was paragraph 80. So this is the authorities bundle, volume 3, tab 26, page 765.
You mean volume 2, don't you?
I do. Forgive me. I've got volume 3.
King and United Kingdom is tab 26. Where's King and Walden? Is that?
Sorry, I mean King versus Walden.
Yeah, which is indeed volume 3, tab 36.
I've got tab 20, tab 26, and my notes are on the.
Depends whether you want King and Walden or King in the United Kingdom.
King and Walden.
That's 36.
So it was paragraph 81, and halfway down, the question came yesterday with a particular line. So if I just start halfway down, just above F, the true legal position is that the ultimate so-called legal burden at all times lay on the revenue. The 1991 primary facts and the 101 presumption, which itself arises from the primary facts, form part of the evidence against him. Look at it another way, there is no matter giving rise to the penalty determinations which the revenue had not, at one point or another, had to prove. So it was that last sentence there that gave rise to the question. And my respectful submission is what that is giving, what that is giving reference to is the fact that under section 95, which is the penalty provision, HMRC or the government under that regime had to prove everything, including the fact that income tax or capital gains was due. They did that via section 101, which deemed or meant the assessment stands as evidence unless rebutted. And so essentially the assessment was, unless challenged or successfully challenged, stood as evidence, and therefore they had to prove everything. But of course, in the scenario whereby the taxpayer had rebutted the burden on the assessment, then the whole matter would have fallen away. So what it's essentially saying is, in that case, in that regime, technically the burden was on HMRC for everything, which they often relied upon for an assessment, which according to 101 would stand unless challenged. So there is a...
Section 95, you say?
Yes.
And where do I see section 95 set out?
That is further up the page. I'm grateful.
755.
755, I'm grateful.
Paragraph 37.
Yes, that's
But,
it. Hang on, can I just read it? So you're making an incorrect return. Yeah, okay.
so whilst the mechanics of that provision differ, and whilst maybe that last sentence or so in the reasoning that we've just gone to, I think it was paragraph 80 or 81, maybe can't cross over into the factual scenario I postulate should be the position in this case, the underlying tenet that the taxpayer has the burden to rebut the assessment still holds through. So although perhaps that phrase can't, that sentence wouldn't be applicable to the scenario for 24 or 41, the same underlying principle still applies as it did in this previous regime, that essentially it was for the taxpayer to displace the assessment and the burden was on them. So although not identical, we say the thrust and the practical consequences were the same, although the mechanics differ. The fourth point would go to answer the meaning that we were discussing yesterday just before we broke as to a particular passage in Khan. So if we go to the case of Khan, this is in volume 2, tab 31, page 582. The particular passage in discussion is at 580. That we
582.
580. That we were discussing yesterday.
Yes, this is.
So this is Roman numeral 5.
Passage I'm afraid I am having difficulty in understanding. So any assistance that can be given. Sorry, my fault.
No. I will make brief submissions on it. So if I just read out the passage. Section 73(9) provides that the assessed amount, subject to any appeal, is deemed to be an amount of VAT due. In a case where either there was no appeal against the assessment or the penalty proceedings followed the conclusion of any such appeal, this provision would appear to preclude any attempt to reopen the assessment for the purpose of assessing the penalty. The subsection does not apply directly where, as here, the penalty is combined with an appeal against the assessment, and the assessment has therefore not become final. But it indicates another link between the two procedures. And then in brackets, I do not see this provision as necessarily confined to enforcement, as Mr. Young argues, nor in the present context do I need to spend time on his argument that this interpretation could cause unfairness in proceedings against the third party under section 61, although I note that under this provision there appears to be a general power to mitigate the penalty. So my submissions with respect of that passage is as follows. This passage relates to section 60 penalty, which is not an issue in this appeal, and thus is not of material relevance to this court. It relates to, obviously, Carnworth LJ's interpretation of 73(9). his interpretation is that where there had been no appeal with respect to an underlying VAT assessment, or there had been an appeal of the assessment and the penalty litigation followed, the taxpayer is not permitted to reopen the question of liability for the assessment in the context of the subsequent Section 60/61 proceedings. It is akin or analogous to the discussion in Kishore Court of Appeal and to some extent PML accounting as to whether the question of underlying liability can be litigated in the context of a penalty appeal.
Save only that this probably refers to the same person, does it?
Yes.
So the original assessment will be on the person. He hasn't appealed it, or the appeal's been determined. Can he fight the issue again?
Yes.
Whereas Kishore was, can a different person fight the issue again?
Yes. But we say it's of limited assistance with respect to the burden of proof and would be a distraction to focus on it in this case. And just to be clear, with respect to Sintra SA, where we were faced with a Section 60/61 penalty, where HMRC was ultimately successful, HMRC did not take the point that because the underlying VAT assessment had not been appealed, the taxpayer was not allowed to litigate the underlying question of liability in the context of the Section 60/61 penalty. So he didn't take that point. We were successful anyway, so it doesn't matter. That's the...
Sorry to interrupt you. You may be right, but at least in Lord Justice Carnwath's mind, it seems to have been of some relevance in his analysis of the burden of proof issue, because all these Roman paragraphs are explaining the view he's come to on the burden of proof issue. That's the end of paragraph 73. He says this view is reinforced by a number of considerations, 1, 2, etc. This is number 5 of those considerations. And I can understand the first part of this passage, which is where there's been no appeal, and so the assessment becomes final, or there's been an appeal and the appeal has been dismissed. So again, it's been confirmed by a court or tribunal. But then he appears to recognise that the subsection doesn't apply directly here because the penalty appeal is combined with an appeal against the assessment. That's what you've called concurrent proceedings.
Yes.
And I'm afraid it's after that it's my fault. I just don't understand what the point is that he's making after that.
Well, I don't rely upon that. I don't rely on that passage. I don't necessarily think all those passages necessarily will have equal weight as to the point. And because, for example, of the position we took in this case, it might be somewhat hypocritical for me then to rely upon on that particular provision. So I don't seek to place weight upon it, and I think it would be, in my respectful submission, a distraction from the key issues you have to decide to go down that rabbit hole, which I think it would end up being. My fifth submission is to make submissions on Khan more generally, and there's sort of a number of different points. The first point is just to pick up on some of the comments yesterday. We say the lack of reference in Khan to the corpus of case law referred to does not make any difference to its outcome of its decision. The decision was still consistent with Article 6. It wasn't per incuriam of Article 6 because it references Article 6. And we say, with the analysis of what we've seen, had it considered that corpus of case law, there's no indication it would have actually come to a different conclusion. Because if we actually go, perhaps I can just say it, at paragraph 67 earlier up in the decision, what Lord Justice Carnwath is doing is taking issue by the concession of counsel in that case that HMRC bore the burden with relation to the issue of quantum. That was the issue, and then he goes on to essentially to explain why he doesn't believe that to be correct. But my submission is, well, even if all that body of case law had been considered in the context, or the Sheldrake paragraph 21, and weighed all that into the mix, it would have come to the same conclusion. The importance of the taxpayer has the evidence there, keeping all the records for the quantification of it. So whilst it didn't examine the full body of the case law that was there at the time, it doesn't undermine the reasoning or the rationale. In the same way, Zaman didn't reference Article 6, but we actually say it was consistent with Drusilla. And in the same way, in relation to the submission in relation to doorstep as well, and it's just how things, because if a point is taken at Upper Tribunal on that very point and then not pursued by counsel and Article 6 in the Court of Appeal, understandably the Court of Appeal doesn't then reference an argument not made before it, but is that decision per incurium of Article 6 when it's been dropped previously? It doesn't undermine the quality of that decision, as long as that decision is still consistent with Article 6, which we say doorstep very much is. Because essentially, again, had paragraph 21 of Sheldrake been gone through in doorstep, I would respectfully submission that the decision would have been the same for the good reason, partly because of the good reason that it is the was it the data controller in that case was in possession of the evidence and knew what happened to it.
I did glance over lunch at the Upper Tribunal decision, which you referred to earlier, and I see, lots of these cases are referred to in the Upper Tribunal, and they certainly didn't feature before us.
But the exact
Whatever you
argument
get from that, I don't know.
But the exact argument is at 162. It's referenced to Drusilla. Sheldrake is mentioned. The burden is on the burden of proof.
And they also, I know, referred to Janosevic and whatever. But anyway.
So, and then the other point, just to sort of in terms of reliance on Khan in the context of this case, obviously bearing in mind what Sheldrake says about each case depends upon its facts or each penalty regime is, we've taken that into account because we're submitting a nuanced interpretation to say that HMRC holds the burden with respect to all the bespoke penalty elements. I could be submitting before this court, but I'm not, a very, very strict interpretation of Khan that says unless statute says otherwise, everything is on the taxpayer. I'm not doing so. We're applying a more nuanced interpretation, essentially to give effect to Article 6, accepting that we have the burden with respect to the bespoke penalty elements.
Well, that I understand, but if I may say so, that does, at least to me, that implies that we can't just take Khan at face value. We have to read Khan subject to being compatible with Article 6 too.
Yes, but I think you would have to read any case as in the prism of Article 6.
Not necessarily. The House of Lords held in Kay and Lambeth that courts below the level of now the Supreme Court are bound by earlier judgments. In other words, our domestic doctrine of precedent still applies, even if we were to take the view that there's an incompatibility with the Convention.
I would still say Khan's still not necessarily inconsistent with Article 6 because they weren't the facts that were before it.
Yes, I understand. Yeah.
So I suppose I take my point that far, and on the because of course in some ways Khan was very much appreciated. It didn't just say that the Section 61A and B categories, the burden was on HMRC. Also, there's also that passage, which is a subject of much debate, that it also said because the underlying question of evasion in that case, also, there was clearly a mind of fairness and taking a stand back view of weighing it all in the balance. So I'd say Khan still is good law and consistent, and if the current regime were before Khan, I would say they would consistently submit with what we're submitting.
The important submission you're making is that you accept that in what you call the bespoke elements of a penalty case, the burden of proof does rest on HMRC.
Yes.
Whatever Khan may say about that, you accept that.
Well, we say Khan's silent because it wasn't dealing with that regime. But yeah, so it's a Khan, again, we don't criticise Khan for that because it wasn't dealing with that regime.
That's right, yeah.
whilst staying in Khan, and just to it is paragraph 74, Roman numeral 3. My laptop's temporarily frozen while I just. So it's just going up the page. And so the bottom of 581, Roman numeral 3. The distinction is readily defensible as a matter of principle. Mr. Young relied on the presumption of innocence under Article 6 of the Convention, but he was unable to refer us to any directly relevant authority. The presumption clearly justifies placing the burden of proof on customs in respect of tax evasion and dishonesty, but once that burden has been satisfied, a different approach may properly be applied. So just in relation to the wording, the presumption clearly justifies placing the burden of proof on customs in respect of tax evasion and dishonesty. That comment, we say, is in respect of this particular regime, given in light of the fact 60 subsection 7 places the burden of proof upon HMRC. The reference to tax evasion there, I think it has been conflated at some points during this hearing and elided with just simple liability to tax. It's referring there to the tax evasion in the context of a section 60 penalty. What this is not saying is that the presumption of innocence justifies placing the burden on HMRC with respect of any tax liability. So the use of the word evasion by itself is, I think, I submit, unhelpful. It's particularly in that context that it needs to be understood. And also bear in mind, again, this is entirely consistent with our position, because of course we say that the underlying liability should follow passport through from the underlying assessment. And of course, when dishonesty is alleged in the underlying assessment, or part of that, we accept there is liability, as we did before the Upper Tribunal. So again, this is entirely consistent with our position. Can I just, whilst just on the back of Khan, but just bury down in a minute, just in terms of the reasonableness and proportionality assessment as to where that balance should lie. Fraudsters charges obviously is hyperbole and is thrown around, but it is a useful badge for these submissions, just to try and take.
Can we put Khan away, or are you coming back?
Oh, we can put Khan away. Just to try and get to the reality of what we're talking when we're weighing up that. What, by putting the burden upon the, and just using this case as an example, by putting the burden on the taxpayer in this scenario, we're asking you to go to the extent of producing records, trading records, which you should already have, and most probably, I haven't cited them, but because of various company provisions, have to keep records for a certain period of time in any event. So that's the imposition that we are asking you to go to, which is to keep drilling down into this, the balancing frame, to keep the records and provide them. The consequence of what is being asked of the state in this scenario is the state losing, certainly the tax gap at one point during this procedure was over £1 billion a year in relation to alcohol fraud. You've got multiple fraudsters operating at the same time, doing the same thing, multiple groups. For HMRC or the government agency to be able to prove that place of supply, you would be having to get probe evidence, you'd be having to get monitoring, you'd be having to get teams of officers on the continent, you'd be having to do this over a prolonged period of time. And then the resources might enable you to do that to one of, say, the 20 different organisations that are doing the same thing at the same time. What happens then if X company decides to set up a different company every 2 or 3 months, and your probe evidence relates to, if you have got the evidence, relates to company A, but you're already on company D at that point, and then the taxpayer saying, well, that evidence doesn't relate to this entity. What happens if, and again, there were indications in this case, the money moving straight out of the company bank account into the director's bank account? The obligation and the consequences for the state on those balancing scales are immense. And Woodley, part of the reference in Janovich, paragraph 103 was the purpose of the personal liability notice of the surcharges was to act as a deterrent. But that becomes much, much more difficult. So, in crude terms, it almost becomes, the fact of this case could almost become a textbook for a smuggling operation. You insert a buffer company, say you didn't control it, so you're not obliged to give any evidence in relation to it, or you can't. Say the goods were sold on the continent, I don't have to prove it. Set up a new company every few months, because evidence you've got for the previous company doesn't cross. The scale of the problem would be immense, versus, this is your company, you should have these trading records, can you please produce them? So on just trying to drill down as to the practical consequences, it would be significant.
You might also have trouble in terms of deciding whether or not to impose a penalty, or at any rate how to deal with things once you had imposed a penalty, in the sense that if Mr Webster is right, do you have appeal against liability and appeal against penalty heard together, you then have the burden of proof in relation to liability as well as penalty.
Yes, I was going to make a submission.
Oh, sorry, yes.
Yeah, I mean that submission, that's against arguably the UT submission on the point of concurrent proceedings. That has, I don't think that's been made before. They've gone that far in terms of saying it. Obviously, it's in the incentive of every taxpayer in that scenario to appeal both concurrently, and distorts the procedures of it. In terms of my learned friend submission, there's only a limited number of cases. I know it's a crude analysis, but that would capture, I think, 23 of the 25 cases in 2024 of VAT penalty cases. So virtually everything. And it would, and that would be a dramatic shift to the current, the way the current regime has worked in terms of the burden being on the taxpayer for the underlying liability and that passporting through.
I mean, I suppose you could attempt to prevent the two being heard together, but then, of course, there'd be resource implications to that as well.
But even then, there'll be all sorts of abuse arguments being thrown at HMRC if we're trying to game the system in terms of trying to undermine a decision of this court as to where the burden should lie. I mean, I'm not sure, one would feel quite uncomfortable advising on that strategy, being a public body, to try and game the system for in that way. I mean, so
it's a melancholy fact of life that whatever system one has, people are going to try to game it to their own advantage one way or another.
Of course.
I suppose we have to try to reach a construction which minimises the opportunities and incentives for that kind of behaviour.
that's fair on both sides, which we say this is.
Both sides. And it's very important, I think, to your submissions on fairness. Is the contrast you draw between the taxpayer who is frankly having to produce documents it anyway ought to have and is obliged by company law and so forth to keep available and all the rest of it, on the one hand, and the sort of Pandora's box which is open if Mr Webster's construction is correct in relation to concurrent cases, which are going to be pretty commonplace, whatever the exact statistics may tell us about.
Or penalty alone.
Or penalty alone, of course, yes. But I mean, yes, yeah. Penalty alone is not quite such a sort of odd-looking proposition to say that the burden does or should rest on the government throughout. I mean, although obviously I'm very well aware that's not what you're arguing for, but it's not quite so instinctively
objectionable as in a concurrent case, where liability is at issue at the same time as penalties.
Yes, but I mean, for all the reasons obviously I've submitted, I don't really see a distinct, and then you still have
I follow that,
significant
yes.
inconsistencies.
Yes.
And the system could equally just be increasing the gain for penalty alone. Just on this point, again, yesterday there was maybe a slight confusion between a sort of a contrast between a company being faced with an assessment and them having to pay it, and a director's liability notice being on a third party. Just so we don't forget, the company, the director's liability notice stems from the company penalty. The company penalty is subject to Article 6 with relation to the bespoke elements. So it's not just a division between company and third party individual. There is it is company dealing with tax assessment and company dealing with penalty. And so I just reiterate that point. I'm not necessarily saying it cuts one way or other necessarily in the argument, but just so that's not lost in the understanding. My next point is just to reiterate, you obviously have my point about how tax proceedings do not fall within the hardcore of criminal law, but there is a second, equally we say a persuasive point, similar but bolts onto that I made on the first day, but just to reiterate, of course, if we are in the position whereby it's not possible to separate, and we're in a situation where is it reasonable proportionate, and we say it's not within the hardcore of criminal law, we're also in that Gisela versus, I think, Finland, paragraph 45, the very end of that, where it says it doesn't apply to the full extent, or I may be getting the exact terminology, but that's two slightly different avenues to arrive at the same point as to why they are distinguished from conventional criminal matters. If I noted correctly, there was a few questions this morning with respect of the section 20 provision in Schedule 41 as to the reasonable excuse provision. I had made submissions on this on the first day, but I think it may just be helpful just to quickly recap so you can have them in context. So that it was. So Schedule 41, I think we're dealing with Volume 1, Tab 14, page 216.
And just pausing very briefly. So we had in the 2007 Act, Schedule 24, and then you have Schedule 41 coming along the following year.
Yes.
That is genuinely new and additional, or not? What did Schedule 41 have equivalents in the old law?
Yes. So this relates to, as far as the VAT is concerned, I'm not going to go everywhere, 63 and 67 of the VAT Act.
Yes, I see.
One related to failure to notify, one related to misdeclarations. So I did go to, so that is.
I'm not doubting that you told us all this.
No. But I mean, it is relevant because just on that, and I'm grateful for the court for raising it, because so those provisions are in the bundle, and I also drew reference to the case of Butler, Volume 4, Tab 53, and Sean Collins, Volume 4, Tab 57. They're FTT authorities, but only just to make the point that this is how those provisions operated under the previous regime. These were non-dishonesty, these were basic penalties with no real culpability conditions attached. So equivalent to...
With already a reasonable excuse let out?
Yes, there was, I think, in subsection 10 of both.
Yeah.
But the way, the reason why I include those authorities is, and you can follow the few vertical lines in them, is this is the issue. It's a concurrent assessment and penalty, burden on taxpayer with respect of assessment follows through to penalty. Is the reasonable excuse provision made out? Burden on taxpayer, yes or no? So there you have complete synergy in a way with how we're saying the new provision works, except for we're accepting for the bespoke penalty elements that we have the burden.
Sorry, can we just, for the purpose of analysis, I know it may not be realistic in practice, but for the purpose of conceptual analysis, can we imagine a case where there is no assessment of people?
Yes.
Either because there isn't an assessment or for whatever reason. And so you have a penalty under one of these provisions, Collins, Butler, say. On your submission, does the revenue have to prove anything in such a case? Or is the burden on every element on the taxpayer?
Under those, remember, just to caveat, we're talking with the old regime.
Yep.
With 63 and 67. Well, it would have been our submission would have been the same on both, whether it's a penalty alone or concurrent. But essentially, the burden was on the taxpayer with respect to everything. But bear in mind, those penalty regimes were they were almost at the level of carelessness or below, as comparison to the current regime. There wasn't a deliberate.
I understand that, but I'm just trying to think how that fits into the conceptual framework of Article 6. And what Lord Bingham said, for example, about the repugnance of the state making an accusation against the citizen for the purpose of punishment. That's the whole point of a penalty.
Yes.
It's not simply a civil debt that you're trying to extract some money from the citizen. You're trying to punish them for not complying with some general rule of law, and you're trying to deter people so that they don't fail to comply. It may be relatively low-level stuff, but it's important to the efficient working of the state. So unless people file their returns timeously and accurately, or whatever other procedural requirement it may be, a state fairly soon ceases to function if you can't rely on basic information like that coming in on a routine basis. So I understand why it's important to have a penalty regime. So we're not talking about dishonesty, we're not talking about carelessness. It's just that, for example, you can't be bothered, or for whatever reason you don't file your tax return, or in a company context you don't file your returns as a company as you're supposed to do. If you do that year in, year out, you get to the position where the state can't tax people because it has no revenue coming in, because it doesn't know what people are earning, what profits they're making, and so on. So all of that administrative machinery is really important, but the way in which the state enforces it is through penalties. And what Article 6(2) says is that if you're imposing a penalty, then in principle the presumption of innocence applies.
I can't say with hand on heart that I thoroughly researched 63 and 67 to be able to give you a definitive as to whether there was any case law in relation to that. But what I can say is that with respect to the penalty regimes that we're dealing with now, we've addressed that concern.
Okay, and in a nutshell, you've addressed it how?
Because although we say underlying liability burden on the taxpayer, we accept the burden for the bespoke culpability element, even for that low-level penalty, to use that terminology. We've got to prove it was correctly issued, the amount, going back to those points I think we went through on day one. So and so you look at Omar Minerals as an example. That passage made clear that the state had to make clear that they'd accurately got the percentage right, and that's in the middle of that passage. So there's still, Zaman makes clear, albeit there are culpability elements there, that you've got to show that you've issued it.
And presumably something as basic as that you've got the right person. You can't send a penalty notice to Lord Justice Newey when actually it was meant to go to Lord Justice Singh. Is that right? Or do I have to, or does he have to prove that he's not liable?
I'm pausing for thought because on the scenario that could then be used, misapplied, with people saying it's the wrong part. I can sort of see how this could.
Well, it may
I mean,
not
in
be-
a straight assessment of tax liability context, the burden would have to be on the person assessed, wouldn't it? I mean, if the revenue mistakenly assess me, then it's incumbent on me to appeal. I don't persuade the revenue otherwise.
Yeah.
And
Well, I understand that, of course, but that's the fundamental distinction between the criminal part of Article 6 and something which isn't criminal. That's the point Lord Bingham was making. That if the state chooses to bring proceedings against the citizen with the purpose of punishment and deterrence, then you're in the realm of criminal law, even if the state characterises it as being a civil penalty.
But we accept that through the burden that we accept on those other areas. Whether that exact example as to the person,
Yeah.
I think I'd need to probably think that through a bit more in terms of.
That's fair enough, and I'm sorry to spring that.
No. But only because I could then see if I had to give an answer one way, and that would possibly be a piece of decision. I could see how that could then be used for people to play havoc with the system.
Well,
so I'm slightly cautious. But
Yeah, no, you're right to be cautious, and I certainly don't want to put anyone on the spot. So that's very helpful. Thank you.
sorry, wait, did you
So I
finish
was-
with paragraph 20, or did you
Yes,
never
so-
get to paragraph 20 because we
So
distracted you?
this was the point that my learned friend made earlier on this morning as to what the provision says that it is for the taxpayer to make out the reasonable excuse clause, ergo inferences it's for HMRC to make out everything else. My 3 points to you on that point were that is not consistent with the Khan doorstep dispensary line of authority. 2, that can't be consistent with the concurrent nature of proceedings and how they operate, because they have never operated in that way. Contrary to my learned friends, what we say is essentially now a new submission that it has that effect for concurrent proceedings. And thirdly, on a more technical reading of it, that provision could be interpreted as saying that it is for the taxpayer to establish the reasonable excuse clause, but with respect of all other bespoke penalty elements, which we accept, it is for HMRC, but that says nothing about underlying liability. I think I'm now going to turn, before I turn to ground 3, if I can deal with the case of CISPay. Suffice to say, this is subject to appeal and due to be heard in now recently being listed in February before the Upper Tribunal. This was concurrent proceedings with the taxpayer arguing that Article 6 applied to everything, including the underlying tax liability in concurrent proceedings, and therefore, contrary to the usual position on disclosure, which I alluded to yesterday, e.g. that the HMRC just serves the documents it relies upon, because Article 6 applies there as a CPS, essentially with, I think, a small anomaly, if that's the correct name of the case, qualification. I'd need to 100% just...
So that's to do with unused material.
It's to do with a material that is adverse to another person's case, but essentially what could be PII.
Yeah.
Yeah.
we tend to point to someone else or tend to point away from guilt. Is that the point?
Yes, it is. Again, I haven't got it at my fingertips, so I just need to be careful on it. But yes,
So it's
essentially,
evidence that you're not relying on yourself, but which may assist the defence.
no, I think that would be the position, because I think the CPR is worded in that sense that you have to provide all information that is relevant. I'm paraphrasing. But if there was information that was relevant but that you don't want to disclose, but that doesn't undermine the defence, but that so you don't want to disclose, say because of PII,
Right.
you don't have to hand over everything
I
that's,
understand.
it's assuming it doesn't undermine. I'm not making a very good job of explaining because I haven't got it at my fingertips.
No, I understand, because there was Strasbourg case law at the beginning of the century on what could be suppressed, for example, using PII.
But so they were making that, we resisted that application on the basis that, even irrespective of these proceedings, on the basis of the Upper Tribunal decision as it stood, and as it still currently stands, irrespective of this case in relation to the matters that we're dealing with, because of the submissions that I've made and because of, for example, and we put in the permission to appeal decision and the reference to paragraph 11, that because the concurrent proceedings, the indication was in the Upper Tribunal that in concurrent proceedings, Article 6 didn't apply, and therefore there is no difference in the disclosure test. So when my learned friend quoted from, I think it was paragraph 14, that was me recounting what the our submission, the Upper Tribunal reasoned. That was not me at point 3 accepting at the bottom line, in such cases, Mr Hayhurst accept that Article 6 would apply to the underlying liability as well as the penalty. I wasn't making that. I was summarising. That is the FTT summarising my position as to the understanding of the UT decision. Then this decision then goes on, and we've appealed it, I think, under 2 grounds. I can't 100% recall the exact phrasing of those grounds now, but if we just look at paragraph 22, Mr Hayhurst took me through a number of authorities which he suggested provided for a complex process of separating matters with a criminal element and dealing with various combinations of when the criminal part was mixed with another matter. 23, to my mind, this complexity appears unnecessary. And then even though we're then dealing with disclosure, the FTT then went to make a number of submissions or discussion in terms of the burden of proof, before then going on at 32 to then arguably take a contrary view to the one that he just said where it found that separation complex and unnecessary. At 33, however, I see no basis in authority for the suggestion that where there is an overlap between, sorry, make sure I've got this right. No, I should be reading from 32. In my view, Mr Hayhurst's contention that Article 6 rights ought only to have been available in relation to penalty-specific conditions lacks a sound footing. The authorities he cites may support a suggestion that when criminal charges can be separated from other matters, that Article 6 only applies to the criminal charges. That seems uncontroversial. We'll pause there. That seems inconsistent with that earlier passage where the judge is respectfully regarding the process of separation as complex and unnecessary. And then at 33, the FTT goes on, however, I see no basis in authority for the suggestion that where there is an overlap between criminal charges and other matters, that the result ought to be that Article 6 does not apply to the areas of overlap. But one of our complaints on appeal is that there's no attempt at separation there. And then at 33, it then goes on to rely upon Sintra in terms of the penalty alone scenario, but the point we were making was in relation to the concurrent scenario, not the penalty alone. So my submission is, but my other submission on this is in the permission to appeal decision in this case, one of the comments from the Upper Tribunal was it will have limited impact, this decision. This is an example, we say, of its scope and span could go outside burden of proof into other areas as well, such as disclosure. And so we say that is evidence of the fact that there could be much wider ramifications with respect of this decision, not just burden of proof. If I could now turn, before I turn to ground 3, can I assist the court with anything else with respect to grounds 1 or 2?
I don't detect any more questions.
So if I move to ground 3, the first point that's been made is that the correct test was applied in terms of might or may have been material. But my respectful submission is that can't be made devoid of context. That has to be made in a context of, is it being looked at as a material in an objective sense, standing back and with no preconditions or presuppositions, or is it being looked at through a tainted lens? And in this context, we say it clearly was being looked at through a tainted lens. And the evidence of that is very clearly in the first sentence of the first reason at paragraph 148, which can be found at tab 6 in the core bundle. With the reasoning, first, the FTT decided the place of supply issue in relation to both Global and SA on a basis which had little connection with the issue of control. Well, that evidences my point as I made the submission yesterday, that they're clearly the Upper Tribunal is clearly looking at it through a tainted lens rather than objectively, because that's an entirely circular argument. Of course, the FTT decided it on a basis that had little connection to issue of control, because it put that out of its mind. So my first point there is that the test can't be looked at in isolation, it needs to be looked at in context. The second point is, I respectfully submit my learned friend Mr Gurney almost conceded the point, because he said in his submissions to you, this issue could of course been material, it could of course been relevant. But he then went on to make submissions how it wouldn't ultimately have been, because HMRC would have been unable to successfully draw an inference or an adverse inference. Well, pausing there for a minute, that is not for you or the Upper Tribunal to go down the hypothetical exercise, we respectfully submit, of what the outcome of that inference argument would have been, because you are not the finders of fact and in possession of all that evidence. As soon as you get to the point in the logical reasoning to say it could or might have been materially relevant, then it has to be remitted, we respectfully submit, and then the finder of fact can, if necessary, hear and make that decision on adverse inference. And to the extent it's not going into the weeds of that argument even more, my learned friend drew reference to the alternative explanation test. As I understand it, and I have drawn my learned friend's attention to this, the Supreme Court, in the case of Ifobi versus Royal Mail, at paragraph 41, has very much regarded the questions of inference as it should be a matter of common sense. So whilst, of course, alternative explanation could be a factor, it is not decisive. And so it would not have necessarily followed that would have been found against HMRC. And also, if we follow through the logic, again, I'm slightly going into the weeds, but if we follow through the logic of what that alternative explanation is, it is, I would be prejudiced if I produced the records, because I would be providing records to say I defaulted on French VAT and French excise duty, TVA. So I'm prejudiced because I would be showing my criminality in another jurisdiction, and then query in terms of whether that, there could be all sorts of arguments that then flow from that analysis, even to the extent that my first point, the only credible explanation is not the only test. It's a matter of common sense. That's a factor that has to be considered. But then, of course, even when you're then weighing that alternative explanation, well, has time matters expired in France? Are you still liable? There's all these sub-debates that would then have to be gone through as to assessing the merits or the evaluation of that point. That's not for you to do. That's not for the Upper Tribunal to have done. Once we've got over the threshold, which was conceded by Mr Gurney, that it could be material. In terms of the point as to whether a case that hangs or falls on the burden of proof can be described as borderline, you will be able to make your own decision as to the evaluation of that. I'm not sure my submissions can help you much further. I pray in aid of, my lord, your remarks at paragraph 40 in doorstep dispensary, which says it's a very rare occurrence for that to occur. But I will let this court make its own evaluation on that assessment. With respect of the reference as to whether the payment evidence was a matter as to why the FTT rejected our case, I don't accept it was, and very briefly, core bundle, page 299, so it's tab 10. And the reference that, well, I've already taken you to paragraph 638, the reference is at 639, and in reference to Mr McGuinness's submission, that the Banjak's convictions and money flows that have been proven to take place are potent evidence that Global was a smuggler of the alcohol and not some innocent intermediary. Well, that is correct, because that was part of the package of our potent evidence once combined with some of the factors I went through when I went through those documents yesterday. but we weren't rejected on that point. There wasn't a finding against us. And in fact, the actual finding from the FTT appears at paragraph 643 and 644. And it's really, as much as we get of a finding, at the end of 643, 3 lines up, accordingly, and applying the same process we did with SA, it would appear that Adrena, not Global, owned the alcohol seized in the United Kingdom, and that it supplied the alcohol that was sold. As such, and the absence of evidence that Global was the owner of the goods that were supplied in the United Kingdom, we're unable to find that it was liable to be registered for VAT. So it was very clearly not based upon the money flows. That was submission, and it still is part of the potent evidence, but it wasn't rejected. It wasn't a matter against us. It was part of our package of evidence. Clearly, the finding, it's being alluded there that it was Adrena that had smuggled the alcohol, because of course they were named on the cover load paperwork. And then a finding that we hadn't proved our case. So I accept going to the Upper Tribunal's point that they found other companies were involved, and so we hadn't proved our case. Yes, because they were finding about Adrena. But our point in relation to that is Mr Malde, who was in control, could very well say whether Adrena was actually smuggling the mirror loads, or, as per the paperwork trail we went through an example of yesterday, was it actually still Sintra Global? If on that time, on the 7th of October, in the 6 hours between when it left the Dunkerque warehouse and when it went across the continent with your haulier, if you're saying you sold that mirror load to Adrena, where's the evidence of this? And so, in reality, what happened at the FTT hearing, in my respectful submission, is the taxpayers are trying to have their cake and eat it by saying, on one hand, we're not in control, so I can't produce any evidence. At the same time, the council team behind that, I don't professionally criticise it in any way, but are then saying, oh, but we're challenging the place of supply. But Mr Malde is saying, well, I can't give any evidence in relation to that because I wasn't in control. And then, of course, we have a finding that we can't take into account control in terms of place of supply, which boxes us completely off. And then Mr Gurney's submission, well, Mr Malde was cross-examined on all these points about, well, wasn't it Sintra Global that was smuggling the alcohol, etc., and all those points. And it's conceded that all those points were put. But of course, Judge Brooks put that out of his mind because he put control out of his mind. So all that whole tranche of questioning that Mr Gurney's alluded to went to one side because control was parked for decision on place of supply. Mr Gurney was right. It was just a matter of me forgetting to make submissions on the second point at paragraph 148. So the paragraph 148, tab 6, reads as follows. Second, it is clear the FTT did not regard Mr Malde as a reliable witness. The FTT regarded much of his evidence, including in relation to Global, as unreliable. There is no reason to believe that the FTT's failure to consider the control issue in advance of the supply issue had a material effect on the FTT's view of the credibility of Mr Malde's evidence in relation to the place of supply issue. In my respectful submission, again, there's a degree of circularity there, but it's precisely because the FTT did not find him to be a reliable witness, they would not have found his evidence on place of supply credible had they taken control into account. And finally, any reference to Sintra SA, which Mr Gurney made at the end, is entirely unhelpful because, of course, control was not taken into account in relation to Sintra SA either. Okay, we were successful. There wasn't the buffer company then of Adrena, but there can be no useful comparison with Sintra SA, or nothing can be gleaned from that. So, my lords, those conclude my submissions with respect of ground 3. I just reiterate, just because my learning friend didn't make submissions on ground 2, but that has a place, even if you are against me on ground 1. Respectfully, I can still succeed on ground 2 if you're with me that concurrent proceedings should fall with the burden being on the taxpayer, and you're with me that in fact the liability to be registered and the Schedule 41 penalties were concurrent proceedings. So it's not entirely subsumed, that officer repeated work in this within ground 1. It is its own distinct ground, just so that is not lost. The final point is I'm in the court's hands as the extent to which I go on to this, is in terms of my application as to if we are successful and the matter is to be remitted, my submission that it should have been before a different constitutional tribunal, and my learned friend fired back yesterday, well, you didn't appeal the Upper Tribunal decision in relation to that. Well, no, I didn't, and I don't, because of course, if I lose on everything here, what is being remitted is the Sintra SA matter of quantum, which is going back before Judge Brooks to determine the correct legal test on the facts as found with no new facts. We don't appeal that decision, but what I did do is put in a notice of variation with our notice of appeal, which can be found at page 9 of the core bundle, to say this, is that if we are successful on any of these grounds with respect to Sintra Global, there is then a question as to what and who should hear any remitted matters. And because it depends upon questions of fact, and we have concerns which I can make out if required with respect of apparent fairness and apparent bias, that any Sintra Global remitted matters, because they're going to questions of fact, should be before a new tribunal. And then if that is the case, you've got an inconsistency, and I apply for the Upper Tribunal order in relation to Sintra SA to be varied to match that of Sintra Global. So I don't apply to appeal the Sintra SA decision. I don't need to, but my application here is with respect to Sintra Global, and if I'm successful on it with respect of Sintra Global, I then apply, as I've put in an application for a variance of the UT order with respect to Sintra SA. My lords, I don't wish to either be presumptuous or to take up the court's time on it now. Do you wish me to make out any points in relation to why we say the HCA test is made out at this stage?
I suspect we don't. I don't know if I don't detect any particular enthusiasm for exploring the point here. No.
I mean, I don't want to be presumptuous. If we were to be, then we can make written submissions.
Yes, absolutely.
Can I just turn my back to make sure?
Yes.
No, I don't think there's anything else from.
No. Well. Thank you very much. Thank all those for speaking roles, and also those without, very much for all their help with this case. As you would expect, we're not going to give judgment here and now, so you will receive the draft in the normal way, and we'd be grateful if at that stage you would point out our typing and similar errors. That won't, of course, be an opportunity to re-argue the case. We'd be grateful if at the same time you would seek to agree an order dealing with consequential matters. If there are points on which you can't agree, can we please have brief written submissions, and then we'd expect to settle points in the order that we make. I ought also, though I think everybody will be very familiar with this anyway, to remind you of the importance attached to the embargo. I think we've already had a list of those who you think should receive the draft judgment. If you think of anybody else, you obviously need to come back to us. The Master of the Rolls is very concerned that the embargo should be fully complied with. But thank you all for your very helpful submissions.
Round of people.